Money Service Operator Licensing Regime, Application Procedures and Licensing Requirements. Introduction. The Anti-Money Laundering and Counter-Terrorist Financing Ordinance, Chapter 615 AMLO, aims to enhance the anti-money laundering AML and counter-financing of terrorism CFT regime in Hong Kong, China, which provides for the statutory requirements relating to customer due diligence CDD and record-keeping for specified financial institutions, and the powers of relevant authorities to supervise financial institutions' compliance with the requirements. In addition, the AMLO also provides a licensing regime for money service operators, MSOs. Under the AMLO, the Commissioner of Customs and Excise, CCE, is the relevant authority for the supervision of MSOs. The CCE may grant an MSO license to an applicant only if the CCE is satisfied that the sole proprietor, partner, director, and ultimate owner of the applicant is a fit and proper person to be associated with the business of operating a money service. Any person who wishes to operate a money service must apply for a license from the CCE. It is to note that a person commits an offence if the person operates a money service without a license. Money service means a money-changing service or a remittance service. A money-changing service means a service for exchanging of currencies that is operated in Hong Kong as a business, but does not include such a service that is incidental to the main business. For example, retail business accepting foreign currencies in transactions, or that is operated by a person who manages a hotel if the service is operated within the premises of the hotel, primarily for the convenience of the guests of the hotel, and only consists of transactions for the purchase of non-Hong Kong currencies in exchange for Hong Kong currency. A remittance service means a service that is operated in Hong Kong as a business, in sending or arranging for the sending of money to a place outside Hong Kong, receiving or arranging for the receipt of money from a place outside Hong Kong, arranging for the receipt of money in a place outside Hong Kong. Under the AMLO and Licensing Guide, the MSO licensing requirement does not apply to the government nor to an authorized institution, a licensed corporation, an authorized insurer, an authorized insurance broker, an appointed insurance agent, and stored value facilities, licensee, or a system operator or settlement institution of a designated retail payment system that operates a money service which is ancillary to the licensee's principal business under their relevant ordinances. Applicants should note that the CCE will not accept an application for grant or renewal of license if an applicant has been exempted from the MSO licensing requirements. Application procedures. Under Section 30 and 31, Part 5 of the AMLO, an application for grant of an MSO license or renewal of license must be made in the form and manner specified by the CCE, that is, Form 1 and Form 2. Application must be accompanied by the fees specified in Schedule 3 of the AMLO. In relation to an application to operate a money service at any particular premises, the premises are required to be suitable for operation of money service. Finally, the applicant must be, subject to thorough consideration by the CCE, fit and proper person to be associated with the business of operating a money service. To ensure MSO's awareness of the licensing regime and requirements, a series of guidelines were prepared from the angle of facilitating licensees and license applicants to comply with the licensing requirements, which include the Licensing Guide, the Guideline on Criteria for Determining Fitness and Propriety, Guidelines for Submission of Business Plan by Applicant. The C&ED also provides practical guidance to assist the senior management of MSOs in designing and implementing their own policies, procedures, and controls in the relevant operational areas, taking into consideration their individual circumstances so as to meet the relevant statutory and regulatory requirements. All these guidelines can be accessible at the C&ED's website. To facilitate applicants and licensees in submitting license-related documents, Money Service Operators Licensing Systems, MSOS, has come into operation since the establishment of licensing regime. An applicant can access the C&ED's website at eservices.customs.gov.hk/MSOS and follow the instructions to submit the license application. On receipt of a license application by C&ED, an applicant will have an acknowledgement receipt of the application. A reminder for provision of any outstanding documents will be issued to the applicant where necessary. If the applicant fails to provide requisite information on the application form, annex and supplementary information sheet, or produce the requisite documents, including business plan and AML policy, within a specified period, the application will be considered invalid and will not be processed by the C&ED. When all the requisite documents are submitted, the applicant will receive a notice for an interview together with a demand note for the payment of fees regarding the application for the grant of a license and fit and proper person test. During the interview, the original documents and payment record will be verified, and the applicant will be required to sign on the application for an MSO license in the presence of the C&ED officers. Besides, the applicant will be required to clarify and elaborate any information of the submitted documents in relation to the license application. For example, its business plan and AML policy provided for the application. With a view to ensuring that the applicant can fully understand and fulfill the obligations of an MSO licensee, the applicant will be briefed on the statutory licensing and compliance requirements applicable to MSOs. An appointment letter for the competence assessment will be sent to the applicant. The eligible person nominated for the assessment must attend the assessment at the specified date, time, and centre. The result of the assessment will be one of the factors that the CCE considers relevant in determining whether the applicant is fit and proper to operate the business of a money service. Failure to attend the designated session of the assessment may result in refusal of the license application. Under the AMLO, in relation to an application to operate a money service at any particular premises, the premises are required to be suitable for the operation of a money service, and where the premises are situated in a mixed commercial and residential building, the applicant has to secure the written consent of every occupant of the premises for any authorized person of C&ED to enter the premises to conduct inspection. To this end, the C&ED officers will conduct on-site suitability check on those applied business premises. It is to note that the processing time may vary and depend on various factors, including the time taken in collecting requisite documents from the applicant, on-site inspection at the business premises, the time required in obtaining records from other authorities to perform a fit and proper person test, and the time taken for completing the competence assessment. To facilitate the application for grant and renewal of an MSO license, the licensing guide provides a non-exhaustive list of supporting documents for application for an MSO license. The C&ED expects applicants should conform to the checklist for ensuring the timely and smooth processing of the application. As prescribed by the AMLO in determining whether a person is fit and proper person, the CCE must have regard to whether the applicant has been convicted of offence related to money laundering or terrorist financing within or outside Hong Kong, or offence for which it is necessary to find that the person has acted fraudulently, corruptly, or dishonestly. Whether the applicant has persistently failed to comply with any requirement imposed under the AMLO, and whether the applicant is the subject of any bankruptcy proceedings or a winding up order. Besides, the CCE may take into account any other matter he considers relevant. In this connection, guidelines on criteria for determining fitness and propriety are promulgated to provide clarity regarding the considerations to which the CCE regards in considering whether to grant a license to operate a money service. In particular, the supplementary guideline lists out examples of matters that the CCE considers relevant in helping applicants to understand what constitutes a fit and proper status. The supplementary F&P guideline provides examples of matters that the CCE considers relevant, which include whether the person has failed to comply with any conditions imposed by the CCE on the license, whether the person has any record of non-compliance with the AMLO or relevant regulation, which resulted in the taking of administrative action, prosecution, issue of written warning, or has been disciplined by the CCE for the non-compliance, whether the person is in compliance with guidelines promulgated for money service operators in the regulatory regime, including the licensing guide and the guideline on AML CFT issued for money service operators, whether the person has the ability to carry out the money service business competently, honestly, and fairly, and in a manner which is not detrimental to the interests of the customers or members of the public. Examples are the contravention of any law designed for consumer protection, or the licensee has been the subject of any complaint made reasonably and in good faith relating to the licensee's conduct of carrying on the business, whether the person has been the subject of any proceedings of a criminal or disciplinary nature, or has been notified of any potential proceedings or of any investigation which might lead to those proceedings under any law in any jurisdiction, whether the person has genuine intention and readiness to carry on the money service business to which it was proposed in the license application. Examples are the person provided nil money service for a prolonged period after the grant of license, whether the person has established effective AML CFT systems to ensure compliance with all applicable requirements under the money service operator regulatory regime, whether the person is equipped with the skills, knowledge, experience, and professionalism necessary to perform the business's functions efficiently and effectively. In making such an assessment, the person is generally expected to be able to display an understanding of the statutory and regulatory requirements that apply to the business. Examples are a person who did not take or failed to pass the relevant test, if any, conducted by the C and ED in the course of processing license application, whether the person has provided the necessary infrastructure and internal control systems to manage risk effectively, and whether the person has financial integrity to ensure that the person has adequate financial resources for the nature and scale of its operations, and the financial position or solvency of the person would not undermine the interest of the customers and the members of the public. Licensing requirements. Under the licensing regime, MSO license applicant is required to submit a business plan so that the C and ED can have a comprehensive understanding of the applicant's proposed money service business and its mode of operation in order to apply risk-based supervision. The business plan should ensure that the applicant pays attention to both the broad operational and compliance objectives of the new business. The C and ED is obliged to look at the applicant's entire business operation from the AML CFT perspective. As such, it is important that the applicant will provide all necessary information to the C and ED for examination and has the necessary resources to execute the business plan and comply with both the statutory and regulatory requirements. To this end, a guideline for the submission of business plan is published to explain key elements required in the business plan. It is important for the applicant to complete a self-AML CFT risk assessment and put in place a set of policy to mitigate the risks of money laundering and terrorist financing. The policy must be based on the applicant's risk assessment and meet its particular business risk profile. Guidelines for the submission of AML CFT policy were prepared from the angle of facilitating applicants to comply with the statutory and regulatory requirements, and in general cover issues on risk assessment, CDD, ongoing monitoring, filing suspicious transaction reports, STR, screening of designated persons and entities by the United Nations Security Council, record keeping, designation of staff responsible for AML, CFT, and staff training. In deciding whether to grant a license, the C&ED has all along been assessing whether the particular premises declared by the applicant are suitable to be used for the operation of a money service. Generally speaking, particular premises should be accessible by C&ED officers for carrying out their functions under the MSO regulatory regime. Examples that are considered not suitable to be used for the operation of a money service under the licensing guide include business name displayed on the signboard of the particular premises is different from the business name registered in the business registration certificate of the licensed applicant or licensee, where other businesses being run on the same premises of a licensee. The money service business of the licensee is not clearly partitioned and distinguished from the other business. Particular premises that are being used by other MSO for operating a money service or being declared by other applicant for grant renewal of an MSO license. Particular premises that are not accessible by C&ED officers for carrying out supervisory functions. The particular premises are designated for specified uses or assigned for specified uses under the tenancy agreement other than money service operation. In short, particular premises to be used for the operation of a money service must be in compliance with the C&ED's regulatory requirements, as well as the restriction imposed on the use of the property. In order to discharge supervisory function efficiently and keep close communications with licensees, the Local Place for Storage of Books and Records, LPS, and Local Management Office, LMO, are regarded as important factors in considering the F&P status of an applicant. All MSOs are required to the information of a local place for storage of books and records, LPS, in Hong Kong, which is a physical place for keeping the full set of books and records in respect of its money service transactions. The LPS must be under the control of the licensee so as to facilitate the C&ED officers' access to them to perform the functions under the AMLO. For an applicant who chooses to operate a money service without particular premises, a physical presence in Hong Kong must be maintained, which will be its local management office, LMO, and correspondence address of the business or corporation. The LMO is a physical office which can be reached in person and through telephone by the C&ED officers to perform the functions under the AMLO, as well as receive document or correspondence from the C&ED, such as circulars and notices to the licensee. Personnel in the LMO must be the sole proprietor, partner, director, ultimate owner, and/or compliance officer, CO, of the licensee. The sole proprietor, any one of the partners and directors of an applicant or a licensee, must pass a competence assessment conducted by the C&ED with a view to ensuring that the senior management of an applicant or a licensee has a clear understanding of ML/TF risks to which it is exposed and is capable of implementing effective AML/CFT systems to adequately manage and mitigate the ML/TF risks identified in order to meet the statutory AML/CFT obligations. Applicants' knowledge and experience in the relevant business and senior management oversight competence are one of the factors in considering the F&P status of an applicant. If candidate failed in the assessment, the CCE may cast doubt on the competence in performing the AML/CFT obligations functions efficiently and effectively. Applicants and licensees may refer to the guidance notes on the competence assessment for MSOs issued by the CCE for further details on the implementation of assessment. Sample questions have been released on MSOS for applicants' reference. Candidates are advised to study the AMLO Guideline on AML CFT for MSOs, Licensing Guide issued to MSOs, other guidelines and circulars issued by C and ED to MSOs, which are clearly elucidate the statutory and regulatory obligations of an MSO.